News.
All right, now the window for hearing election petitions stemming from August 8th poll closed yesterday, opening a chapter for appeals. It has been a tense season with a petition asking a few and many surviving. But what has stood out has been the hefty fines imposed on losers. So what happens to those who cannot pay their fines? Still, this morning we revisit the calls to reduce the number of members of parliament amid soaring wage bill, with Third Way Alliance Party leader Ekuru Aukot recently capping the number of lawmakers at 194 from the current 416. Is the country ripe for a referendum? Welcome to the Political Point this morning as we digest this and more, and I'll go straight to introducing the panel that we have here this morning. To my extreme left, we have Barak Muluka, who is a man who's well-versed in matters governance. Good morning and thank you for joining us.
Good to see you.
We also have Professor Wajakoya, who's not a visitor to many or a stranger to many, who's an advocate. Thank you for joining us.
Thank you.
Last but not least, we also have Philip Magal, who's a lawyer as well. Thank you, gentlemen, for joining us this morning to just digest and look at the political point. And a quick reminder of the question that we have this morning is whether we should reduce the number of members of parliament as per the proposal given by Third Way Alliance leader Ekuru Aukot. Is that a solution that we have for Kenya? And I'll be reading through your comments as we go along. Also, you're welcome to participate in the conversation with the Twitter handles now displayed, and the hashtag is Morning Express KTN. I'll start with you, Professor Wajakoya, looking at now petitions being closed and your comments, first of all, on the fact that one thing that stands out, just like I mentioned earlier, is the high cost of losing a petition, whether that is the right way to go. Maybe the rationale behind it is to reduce the number of petitions that possibly would not meet the threshold. But secondly, could it also work against the whole system by virtue of the fact it discourages anybody who loses to even trying to petition when you think of how much you'd have to be slapped with after? I mean, you're talking about amounts of 5 million, 10 million, 12 million.
First of all, let me take this opportunity and send a message of condolences to the late Judge Onguto. I equally would like to say that I joined members of his family and also appeal to the Kenyans to pray for the family. Onguto was my friend. While he was at London School of Economics, I was at School of Oriental and African Studies, and we were taught by one person. When I came back, he taught me, so my condolences. Now, when it comes to this rhetoric of fining people exorbitantly, that in itself is unjust, is uncouth, unconstitutional, bearing the fact that it's not the judge who comes up with the fine, it's the litigants who come up with the costs that have been involved. But even if that was the case, why would that amount go in constantly as if both judges or all judges are reading from the same script?
What is it that determines the amount of money that they're paying? Because maybe it would be good to also just understand how those figures are come up with.
These figures are computed on what the bill of costs is from both sides. The amount of time lawyers take, witnesses, days, and also the filing. And if I don't go deeper, probably my colleague here will go into details. So the judge's role is to look at what's being put on his table by both parties demanding what they have actually spent on litigation. And of course, the loser pays the winner. Looking from that perspective, yes, that's okay. But then why are the courts doing the same uniformly?
All right, Philip, the costs, do you think those are justified? Because maybe the rationale is to ensure that you're very sure that you have a case before you present it.
You already know whether or not you do have a case unless it's tried and tested before a court of law. The overall effect of this high cost would be that most people would be dissuaded from filing election petitions in the future. In fact, I can say for certainty that come 2022, there will be very, very few petitions unless the appeals overturn these costs. And the public is made aware that they still do have access to justice undeterred by costs. On the question as to how these costs are arrived at, that is the most contentious issue. It is arbitrary. Most courts at the end of the petition will just say, like we saw in the Oparanyas case, the failed petitioner is to pay 13 million to the respondents. They are not assessed based on anything. As much as they seem, the only consistency amongst the different awards given is that they are high. But they are not based on any...
So once you realize you've lost, can you just come up with a bill, basically just come up with any amount? Isn't there a formula of sorts?
So far, no formula. There have not been any bill of costs filed by advocates. Those who lost the election were arbitrarily slapped with costs, whimsically, capriciously by the courts. The courts didn't consider how many, the nature of the petitions, whether it was merited or not. They didn't consider the number of applications put in. They didn't consider the caliber of the competencies of the advocates presenting the different parties. It was very much arbitrary, and that is what we as legal professions are taking very much unkindly. Because election petitions are part and parcel of the electoral process. They do constitute an audit of the electoral process. It is, at the end of the day, it is these petitions which tell us whether the petitions were competently handled or not. And therefore, all those with grievances, the parties which took part in the election, as well as any person who's affected by the election, should be given access to justice.
All right. Barak, do you think then maybe there should be a cap put on those costs, especially by virtue of the fact it is a trial of democracy when you're able to access justice through the court system? However, when they become that high, then definitely it becomes a discouraging factor.
I'm probably not flowing in the same stream as my two colleagues on my right, and therefore I would perhaps not make my conclusions based on the premises of what they have stated. First, the court system has got the responsibility the world over of taxing legal fees. If, for example, you have a matter before the courts and your advocate gives you a fee note that appears to be too high, you can go back to the court, and the court will tax that fee note and will determine that this is the correct amount that you should pay. And their formulas, their systems, their methods, I think it becomes rather dangerous, perhaps even a bit naive, if we begin making blanket statements against a court system and condemning the judiciary, the manner in which it has dealt with these cases, and even start being emotive about it and making accusatory assertions like I've seen, not just here, but I've read elsewhere, I've heard on radio, without interrogating the factors behind this. It is possible that somewhere within the judiciary they sat down and they agreed that this is the formula that we are going to use to tax these election appeals in this season. And some of that is meant to be deterrent, deliberately so, because there are also lots of frivolous cases that are being brought before the judiciary. You have come through an election season and someone is dragging you to court on very flimsy and frivolous grounds. Some of them are even extortionists. There are people who are telling you that tell so-and-so to bring so much money so that I can drop this case. I'm aware, as a Secretary General of a political party in this country, that there are people who have come to me and told me, Barak, there's a payment. Mheshimiwa so-and-so and so-and-so in your party. If they bring so much money, we will drop this case. And on the basis of that, I think those kinds of people must be deterred from engaging in that kind of frivolity. But beyond that, there could be space and ground for questioning the quantums. And if there's a basis for that, then it behooves those who are concerned to go back to the court and appeal even against the fees.
The bill.
You know, the appeal processes are not usually restricted to the judgment that has been made that you have lost. It's also extended to the kind of punitive measures against you
that have been taken. All right, Philip. Yeah.
Just as a rejoinder, I personally prosecuted and defended a couple of petitions, and the courts have the discretion to strike out a petition at the initial, very first, early stages, if indeed it is not merited. Therefore, meaning that it would be unwise and imprudent for a court to go the whole log only to punish you with costs. And if anything, there's no way it is stipulated that costs should be used to deter people from filing petition. Nowhere in the laws is it provided that costs should be used as punishment.
There has to be some control measures, because if again you just let it be an open check, you will have, like what Barack is referring to as frivolous, cases which keep the courts just basically jammed up.
That is why I'm saying that the courts can, at the very early stages of the petition, immediately it's filed, they can peruse it and throw it out.
Mike,
the
next thing you would hear, if I may interject, is that people are being denied the right to be heard.
Correct.
We know, for example, that just now notice has been issued to the court of the Supreme Court, and we know that it's a process that began with regard to the Kirinyaga gubernatorial seat,
yes,
where the case that was filed by Mheshimiwa Martha Karua was struck out at the stage that the Learned Council is talking about. And everybody would be wondering, and they would be saying, no, let there be the opportunity to be heard. That is the flip side, that if these things are being struck out at that point, everybody is going to start saying, but why couldn't they have allowed the hearing to go on?
Of course, the courts have to give a reason for their decisions. And of course, they would have to explain why a petition was struck out at the preliminary stage. That is number one. Number two, the right to hearing is universally accepted as a human right.
But let me cut you short. My assumption, or our assumption, is for them to allow the proceedings to carry on.
Yes.
There is adequate, they've met the threshold.
Yes,
of
they
what
have
is
to
required for them to be heard.
Yes,
and as a result, cannot be struck out at that point. They have to be heard right through because they've met that threshold.
No, first, when you file your petition, the court has the mandate to go through it. It is then to be listed for hearing only if it is merited. Otherwise, if you put in a frivolous case, then it should be thrown out. It should be struck out at the initial stage. And that is what the law provides.
Okay.
Yes.
All right. Professor Wajakoya, your thoughts on that before we take a break, and possibly what recourse do those who've lost the petitions have, especially if they cannot afford that fee note?
I think they should actually petition the Chief Justice to look into the whole affair. And secondly, there are two kinds of judges in this world. We have the red light judges and the green light judges. The green light judges are those judges who look into issues with activism, judicial activism. But if you look at the school of thought we have here and you look at the judge in Keter's case in Eldoret, and I'm not here to speak for Keter, but I'm looking at what he has done on 2 occasions. If you look at his reasoning, and I'm yet to read to find out how he arrived at that conclusion, ruling and that one of Babu Owino, you'll find out that I would liken these 2 judges to a red light judge. Either they are influenced by the political system or they are dancing at the whims of somebody else. For example, in Babu Owino's case, how would you ask for a recount? A recount is done. Then you find out that Babu Owino has won more votes than. And then you come in and say, but the process was flawed. And then, it is politics, but let me not go beyond that.
Barack Muluka, do you think that there is a political hand playing in this? And also the danger that we would be putting ourselves in as a country when a judgment is made and we want to politicize it?
There's a possibility that in some of the cases, the hand of politics, an external hand could be there. But I'm worried about making blanket statements about the whole process and look at the judiciary in its entirety and say that it has been influenced in virtually each and every case. I think each case should be interrogated on the basis of its merits and demerits.
All right, and well, it is now, sorry? You wanted to say something?
No,
He wanted to agree with
He
me.
wanted to agree
well, I agree on that one.
on that particular
Yeah, the
one.
merit part of it, yes.
All right, it's now 28 minutes after 7 o'clock.